effect of minor procedural errors which have made no difference to decision making. I regard it, as do other noble lords who spoke, as an attack on the rule of law, and in fact an attack on parliamentary democracy. To take the example given by my noble friend Lord Leicester, where a statute is passed by Parliament, often after discussions such as the ones we've had on this bill, which requires that the government consult before making a decision, it should not be open to government to flout that requirement imposed by Parliament and then claim an immunity from judicial review on the basis that a lawful consultation would have made no difference to the outcome of the decision making, so that permission should be withheld and relief should be withheld. That is the heart of the point made by the noble Lord, Lord Dean. My Lords, Lord Pannick's public interest amendment reflects an amendment I moved at committee stage. If carried, and if this House insists on it, then a court will not be compelled to say, where a government department has acted unlawfully, that the decision would have been the same anyway, and therefore permission to apply for judicial review must be refused and relief must be withheld. The court will instead be able to say that the decision was illegal, and before it can be properly made, the government must follow the law, quite simply because that is what the law requires. That is the rule of law. That respects the will of Parliament. That gives effect to the principle of government accountability. This House has a constitutional duty to be very careful indeed when what is happening here happens, when the executive is seeking parliamentary sanction for breaking the law as this clause does. My Lords, I shall support the noble Lord, Lord Pannick's amendment.
The question in this particular amendment is rather a simple one. The courts have developed law in relation to situations in which the outcome would not be any different if the conduct complained of hadn't occurred. And my understanding of the decisions in that area is that the court may, if it concludes that the result would inevitably be the same, that the relief is to be refused. Now, this amendment that the government proposed, which is the subject of this fairly substantial debate, simply raises the question whether it should be inevitably or should be highly likely. And in the civil law, of which the judicial review is part, the ordinary rule is that the balance of probabilities determines the fact. But that's the question that was raised here, and I must say I think there's quite a lot to be said for that particular point of view. But I must say that I think the situation tonight is affected by the way in which the debate was conducted in the other place. It's not for us, not for me certainly, and I think not for any of your lordships to criticise what happened in the other place. On the other hand, the Lord Chancellor has apologised to a member of the other place for the mistake that he made, which is fairly fundamental to the consideration of this particular amendment. And therefore, for my part, I would like to see this going back to the House of Commons, not necessarily in order to change the result, that's a matter for them, but in order that the debate should be proceed on a basis that is 110% correct.
My Lords, let me begin my concluding remarks, which will be short, by saying how much I agree with much of what has been said during the course of this debate. First of all, the government and I have great respect for our judges and their capacity to deliver justice in the course of judicial review and in any other field. I also have, of course, profound respect for the rule of law. And in particular, I respect the role of judicial review in upholding the rule of law. And I don't for a moment believe that anything that we do in Parliament should provide any form of carte blanche to a minister or any other public body in the way they conduct affairs. May I also say that the government very much appreciates the report, the careful consideration of the Joint Committee on Human Rights and the Lords Constitution Committee and their respective reports. They were not referred to by anybody on either side during the course of the rather truncated House of Commons report. I don't know the extent to which they were, as it were, taken into account sub silentio, but of course they are important and I fully acknowledge them. Nor do I suggest that failures of consultation are not capable of being serious matters. It is not the government's contention that failures to consult should be regarded necessarily as trivial. Far from it. The clause refers to substantially, and the government's intention is to ensure that judicial review focuses on issues that might have made a difference, not mere technicalities. And we don't consider that this clause will give public authorities carte blanche to act unlawfully. No decision maker is going deliberately to do something unlawfully on the basis that they might hope that they can survive judicial review on the basis of inevitability or highly unlikely in terms of the outcome. I accept what the noble and learned Lord Wolfe said about the importance of declaratory relief and how it can play a very important part in ensuring that public bodies understand their rights and responsibilities. It seems to me that a judge looking at a particular case, if he or she considers that it is important that there should be a declaration, is most unlikely to decide that this case should not go further forward. However, as my noble and learned friend Lord Mackay so correctly said, there is nothing revolutionary about a judge looking at a case on the question of what the outcome would be. In particular, may I refer the House to the well-known case of Cotton versus the Chief Constable of Thames Valley, 1990 IRLR, that and a number of other cases to the same effect, decided the court should look beyond the narrow question of whether the decision was taken in a procedurally proper manner, considering the wider question of whether a decision properly taken would or could have benefited the claimant. Much of the law in this area is concerned with consultation. Whilst consultation can be very important, if it is a trivial omission, it is appropriate that the court should look, and is capable of looking at a particular case and say, well, I do not think it is an appropriate use of public resources or individuals' resources for a judicial review to proceed, notwithstanding the putative unlawfulness, if in fact it would have made no difference or highly unlikely to have made no difference. That is why I feel able to agree with much of the rhetoric around this important point of principle, because what the government are inviting the House to approve is a minor change to the existing law. We are not abandoning judicial review. We are not inviting the government, local government, ministers, public authorities to ride roughshod through the law. We are simply saying that it is possible the judicial review may be reviewed. Judges can be relied upon to prevent that abuse. But it is not inappropriate, I suggest, for Parliament to say, if you, as a judge, consider it highly unlikely it would mean no difference, we invite you, reviewing the facts and not fettering your discretion, to decide that the case should go no further. The noble and learned Lord Wolfe made some serious allegations about the Lord Chancellor's regard to the rule of law. That is a matter which he's given evidence, I think, to the Constitution Committee about. The government believes that the reforms to judicial review are a part of a natural improvement of the justice system. They are not fettering the independence of the judiciary or of the very useful and indeed fundamental role that judicial review forms. I don't think that anybody could realistically suggest that judicial review does not sometimes come up for abuse. It remains valuable, more than valuable, critical. But I suggest that this reform is a modest one, and it will indeed satisfy the very public benefit and the public interest which is featured, but unnecessarily so, we say, in the amendment put forward by the Noble Lord panel.
The Minister sits down. I wonder if I might just ask one question of him. How does he answer the second part of the Noble and Learned Lord Mackay of Clashford?
It is a matter entirely for the House. The whole of the speech was before the House of Commons. It was clearly regrettable. The Lord Chancellor has written a letter. The letter is deposited in both Houses, and this House will take the view that it thinks is appropriate.
My Lords, I'm very grateful to the Noble Lord, the Minister. He has been put in a quite impossible position, not, I think, for the first time, and I sympathise with him. My Lords, there are two central points here. The Minister accepted, very fairly accepted, that the Lord Chancellor inadvertently misled the House of Commons when it considered the amendment that was approved by your Lordships. The Lord Chancellor misled the other place on the very issue which is at the heart of this amendment. He wrongly suggested that there is an exceptional circumstances provision in this clause which confers discretion on the judge. My Lords, that alone is reason enough for this House to invite the other place to think again, and to do so on the basis of an accurate statement by the responsible government minister as to the terms and effect of the clause which he was putting before the House of Commons. But, my Lords, that is not all. The public interest amendment is essential to the rule of law. My Lords, that a Lord Chancellor should regard the need for a fair procedure and for legality as unimportant technicalities which should be excluded from judicial control is, to my mind, profoundly depressing and alarming. And that is not, I say to the Minister, a matter of rhetoric, it is a matter of substance. The Noble and Learned Lord, Lord Mackay of Clashfern, suggested that this clause is a development of the current law. But, my Lords, the change is not merely to alter the test of inevitability to a test of highly likely. The vice of this clause, which we are tonight debating, is that it imposes a duty on the court in all circumstances to throw out judicial reviews without retaining any discretion in the public interest. My Lords, the Lord Chancellor and the other place should be invited to think again about the need to retain judicial discretion in the public interest, as Amendment B1 states. I wish to test the opinion of the House.
The question is that Amendment B1 be agreed to. As many as are of that opinion will say content. The contrary not content. Clear the bar. That opinion will say content. The contrary not content. The contents will go to the right by the throne, the not contents to the left by the bar. My Lords, that have voted contents, 274. Not contents 205. Contents have it.